Good evening, Carl Steinbeck here, covering more of the Commonwealth of Massachusetts versus Karen Reed. And today we had day 22, and we still have this doctor from Aperture, Judson Welcher, on the witness stand. They finished up direct and they got into cross-examination today. They did not finish it up. And so let's go right to the ruling here. Remember, we had some argument of counsel yesterday to the end of the day. And so here we get the ruling from the judge this morning.
All right.
I mean, does this judge look like she's ready to go in the morning? It looks like she's all frazzled and not ready to go. And, this is a late start of the day. This is like an hour and 14 minutes in the live stream. So they're starting really late again. And I think they did announce that it's a 10 o'clock showing start time here. But anyway, it's just really amazing how much time they waste.
Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition,
reliable methodology? How did that even come up as a reliable methodology?
Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work.
Experimental work, that's right. Experimental work never known to man before is reliable expert testimony.
Came into evidence without objection as to scientific methodology and application.
So she's saying that there was no objection to this, and so therefore that she's going to allow it in. So they did raise an objection for you to raise this as a ruling. So what do you mean they didn't have any objection? They should have objected earlier, I understand, but they did raise this objection at this point. He's coming to his ultimate conclusions to finish up his direct. So just so bizarre.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher...
Oh, so the ultimate issue is not a bar to admissibility. I saw that in one of Brennan's motions. So that's like unheard of in the rest of any state I've ever been licensed in or any case law I've ever researched. You don't have people come up there and say make the ultimate conclusion somebody's guilty. Yeah, I think they're guilty. I mean, you could have a parade of witnesses saying, yeah, I think that so-and-so is guilty. And it just invades the province of the jury. That's a phrase that any criminal lawyer would know. So, but again, Massachusetts, they just pretty much trample on the Constitution up there. Besides this one in this court, this is like the worst it gets. But just in Massachusetts in general, it's like they're so behind the times, and they've been doing it for many years, but they do not follow constitutional standards that we have in the rest of America.
The expert is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right. So
okay, so this ruling is, when I'm looking at it here, typed out. Okay, if you stop to think about it, she did not allow ARCA to testify as to any of this, and now she's going to allow this guy Welcher to testify to this. So what is it? What changed? And so I don't know if you guys saw that last night, but if you noticed my title for tonight, I just want to recap that real quick because I was hoping this would come up today in cross-examination. So let me just highlight this real quick. Okay, check this out here. This was Carol Cavey versus Christopher Simons. This is from 2022. It is a Massachusetts case. So the plaintiffs did a motion to exclude the testimony of Judson Welcher, and the judge allowed the exclusion of his testimony. So he couldn't even testify in court. And he tried relying on somebody else, like Carrie Alvino, on a delta V calculation. And delta V's, with the way this Alvino calculated it, was unreliable, therefore rendering the whole underpinning of Welcher's analysis reliable on that point. Second of all, they said the relevance of Welcher's opinion is questionable because his analysis is not sufficiently tied to the facts of this evidence. They cite some other case law from 97 and 2005. And they give a little summary of what the case is about. The second one, it says expert testimony is admissible if, in addition to the reliability of theory and process in general, the process is reliable when applied to the specific issue about what the expert is proposing to testify. So it goes on to say, while Welcher cites one study involving persons of a similar age with similar pre-existing conditions to the plaintiff, although he does not identify the size of the test of the individual, he does not identify the characteristics of any other individuals involved in the nearly 1,000 tests upon which he relies. In fact, Welcher's method of analyzing the impact of an accident on a particular individual by relying on how similar impacts have affected other individuals has been deemed unreliable by the Society of Automotive Engineers because of the variation of individuals' tolerance for physical force. So here he is trying to compare himself to John O'Keefe, dressing up as John O'Keefe as he was on the night he was murdered, and they're saying here this is like unreliable what he's trying to do. He's a one-man unit here. He's a one-man crash dummy trying to replicate this as like science and something involving physics when he's just sort of standing next to a car, or else the car is backing into him at 2 miles an hour. That's this fifth grader's experiment that he's trying to pass on as reliable evidence to convict somebody in a murder case. This is like absolutely outrageous. And then it says, similarly, there's no indication whether any of the studies involve vehicles of the same size or weight as those involved in this accident. So I think based on this case is why he probably decided, hey, I better go out there and get the exact same car. And that's why he had to get one from Texas, because he works in California and they have emissions controls that are different there than every other state. So they wouldn't have had one exactly like Karen's with this extra emission stuff they have on it. So that's why they had to get one in another state. Anyway, going on here, it says, finally, one of Welcher's opinions, that which was no structural damage or failure of the cervical disc occurs, is based on cadaver testing, which is an unreliable method for analyzing how force affects live human beings. So you got two things right here that he's been found to be unreliable. It's not admissible in a Massachusetts court. And he's talking about similar things here in Karen Reed's case. And this is a civil case. It's not a criminal case. So here it's even less of an issue. They're just talking about money damages here for the plaintiffs at issue. Here you have the life of Karen on the line, whether she's going to spend life behind bars or not. So anyway, that's why this thing is really something I thought defense would have brought out right away this morning to show how unreliable his testimony has been in Massachusetts courts, and I think there's another case from another jurisdiction as well. So let me see here. There's also, I want to bring up here. Here was the motion. I covered this last night too in more depth. I just want to go over this really quickly. Here it says the expert opinion must be rooted on record evidence and not based on speculation, conjecture, or assumptions not supported by the evidence. Him trying to say that's how John O'Keefe was killed, or that it's consistent with him being killed by Karen's vehicle, is just wild speculation. No judge would allow this, in my opinion, except for this court there that Karen's before. Expert testimony may be excluded where there's too great of an analytical gap between the underlying data and the proffered opinion. There's a massive gap. You couldn't get more of a ridiculous gap because the experiment is not something that he can cite in any other studies. And he just replicated a couple times. We saw one of them, and it's using him. That's not in enough comparison of John O'Keefe's body. So anyway, it's just really strange that here, one of the things they said, Alvino and therefore Welcher failed to accurately, I should say, document the vehicle's position during the collision. So Alvino concluded without any evidentiary support that the front of the cargo van came in a contract rear end of the plaintiff's vehicle with both vehicles aligned in a straight line at the time of impact. So there's a dispute of that. Sort of like what we have here. We have a dispute of, hey, where's the vehicles at? We don't know. Despite this evidence, Welcher's opinions assume the defendant's vehicle was aligned with the plaintiff's when it struck its rear end. This assumption is not accurate. The positioning of the vehicles at impact dictates the direction movement of plaintiff's body as a result of the collision. Welcher cannot give reliable opinions about the effect of force of the collision on the plaintiff when he has an incorrect understanding of the direction of the force and the positioning of the vehicles when the incident occurred. That's what we have here. We don't know the position of John. He can't say, I know for sure John was standing right here on the side of the street or on the curb or on the grass or 2 feet from the flag. But we don't have any of that. He can't describe exactly where Karen's vehicle was at. They say, in addition to the direction of force, Welcher also purports to analyze the effective measure of force or the delta V experienced by plaintiff's body in the collision. And then relying on Alvino's conclusions, Welcher opines that delta V's result of this incident were in the range of 3 to 5 miles per hour. This calculation is entirely speculative and based on assessment of evidence, which was destroyed by the defendants, including photographs of the defendant's vehicle after the bumper had been bent back with a crowbar. The damaged portion was removed with a sawzall, which is like a saw that can cut through metal and plastic and wood and stuff. And he went on to say, where Welcher's assumptions regarding the force caused by the collision are not accurate, his opinions about that effect of the force on the plaintiff's body must also be incorrect. Or else, if you don't really know what happened, you can't describe, you shouldn't be allowed to describe, hey, this is what this part of the car aligns with hitting this part of the body. And so let's see here. In this case, Welcher admits he did not examine the collision or conduct any testing. So he really just went in there freewheeling it. And then it says here, all of the studies that he cited were done on cadavers or live human volunteers who are aware of a pending collision. Well, that's what he was talking about in his report, he's talking about cadavers dropping heads from bodies from 40 inches above a hard surface. Welcher's alleged research, quote unquote, asked this court to accept that no person could suffer an injury in a rear-end collision at less than 10 miles per hour. This opinion goes too far and contrary to everyday experience and common sense. Now, this is what's in the brief for the plaintiffs. I need to clarify that, so that this is what led to the court making the opinion that I first cited. And here they cite two other states, Washington and Colorado, that basically say, you know, there's no proof that these experiments were conducted under circumstances substantially similar to those existing at the accident scene. How can they recreate that accident scene? It's an absolute joke. The court found the expert's opinion speculative, founded on assumptions lacking sufficient factual basis, relies on dissimilar testing, contains too many disregarded variables. Yeah, like maybe he got beat up somewhere else and not at the scene. What has he done to rule out any other source of injury other than Kieran's car? And the court found that testimony is unreliable as a matter of law. Well, that's why I think any court would find about this Welcher testimony as well here. It said here, Welcher's own literature acknowledges that cadaver testing is not a reliable way to study the impacts of rear collisions on the human body. Welcher noted that response obtained from rear-end studies employing surrogates such as cadaver or dummy testing remain of questionable significance. Cadavers clearly lack muscular input, which is likely an important contributor to occupant kinematics in low-speed rear impact. So here you have Judson in his own write-up in 1994. He's saying that cadavers and test dummies are questionable significance. And he opined that cadaver testing is not capable of accurately stimulating live human response. They're also citing that the reference literature involving a 58-year-old subject is clear that the testing was performed under vastly different circumstances than the rear-end collision in this case. He can't prove that there was a rear-end collision, number one. Welcher admits the subjects were aware of this study and instructed to relax and simulate an unanticipated impact to the best of their abilities. It also goes on to say Welcher's methodology for determining the alleged effect of collision force on the plaintiff's anatomy is not reliable. Look at what he says here. In this attempt to explain the effects of collision force on the plaintiff's anatomy, Welcher compares the alleged forces generated by the collision to acceleration forces that test subject experience doing everyday activities like jumping, skipping rope, and climbing on monkey bars. Like people do that all the time, every day. The relevant scientific community has expressly rejected this methodology and the idea that someone's personal tolerance to an injury can be determined by comparing them to studies measuring forces experienced by other people performing everyday activities. Anyway, that goes to tolerance levels of different folks there. Now look at this here. Welcher, a biomechanical engineer, is not qualified to render expert opinions about medical cause of plaintiff's injuries. Now it says here, it's well said that a biomechanical engineer is not qualified to render opinions about the cause of medical injuries. And that's Massachusetts Appellate Case 93. And it says that opinion had to deal with while biomechanical expert could testify to the speed of the collision of the falling child with the floor, he's not qualified to evaluate the medical consequences of falls from various heights. And here, the proof of any causal relation between the accident and disability must rest upon medical testimony. Another case in 2020, Levy Farrow, Judge Cowan had an order excluding expert testimony by defense biomechanical engineer. Welcher knows he is not qualified to give the proposed opinions of this case. In his report, he goes to great lengths to attempt to argue he's not giving opinions about the cause of Carol Cavy's injuries. And he went on to say in this case, I've not in no way, shape, or form have I made any type of diagnosis. Despite his shrewd phrasing, it's obvious Welcher has attempted to do just that. The entire purpose of Welcher's proposed testimony is to suggest to the jury that the impact was not severe enough to cause neck and shoulder injuries Cavey suffered, and which all of her treating medical providers have causally related to the motor vehicle collision of November 2nd of 2016. He reviewed the plaintiff's medical records and expert medical reports in the case, and he readily offers medical causation opinions about the cadaver and human volunteer testing site in this report. Then he went on to, I guess, went on even further and said that the causal opinions offered by the plaintiff's medical providers are not reliable. So there he's even attacking the medical folks. Anyway, that was what they did in a motion to get him excluded from testifying. See, he filed here May 6th of 2022, and then I already covered the order. So anyway, he's not allowed to testify here in this court a couple of years ago, and now he's testifying to this similar kind of stuff here. So it's just really mind-boggling why this is going on. All right, so let's go back. All right, so then he just basically goes through his ultimate opinions here. I'm not going to cover his direct, so let's just jump to 139 on cross with Alessi. Look at what kind of a guy just takes control of the courtroom like that. He says, good morning. Anybody else will say good morning or good morning, sir. And he's right away owning the courtroom here. Look at this. Oh, like you don't know what this guy's name is. What do you care what his name is? Are you going to be calling him Robert? I think that right there is a good indicator of where this guy is going to go the rest of the day and the rest of his testimony here. All right, hold on. Hold on. I didn't get this captured. Hold on. Sorry about that. Thought I had the shared screen. Backing up.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
You haven't been formally introduced. I was just saying that this is like so bizarre for a witness to start socializing with the attorney questioning him. Yeah, it is cringy.
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you. Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is accident reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
yes.
yeah, certainly for the court of law, yes.
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Yes, the motion was approved that I was talking about.
Yeah.
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So,
Well, he has a financial dog in the fight, and that's what I was hoping they'd bring up this morning. And anyway, we'll get to that here in a minute. Few
in
minutes.
terms of, you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis, is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for
I can't believe he'd want to have this peer reviewed because it would never meet peer review scrutiny.
peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sir,
to
to
get
interrupt
peer,
you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think With the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure...
Well, that are things in the NIST, so I don't think he really knows what the NIST is about.
Failure analysis, the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences. Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have?
you're trying to figure out though exactly what happens from the get-go. You don't know the answer, but you're trying to find this out. This guy's just trying to make a spin on everything, unless he's trying to make a point on just to throw confusion bombs out there.
What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
Yeah.
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end? How do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying.
He doesn't know what cognitive bias means, so that is something he's making it sound like that's for psychologists or medical folks. It doesn't apply to him.
Hypotheses does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses.
I just wish Alessi would have started going into this guy's motives. I think motives for this guy are in any expert, and he's going to be, especially if he's like this guy and he's very evasive on his questioning. He's trying to throw him off, constantly trying to throw off Alessi so far as what we see here. So I think getting into his motives and the money factor here right off the bat is the best way to sort of let the jury know what this guy is about. So getting into all this semantic stuff here, I think Alessi's not getting much traction here, but I think that this guy's coming across as a wise guy. So I don't think he's impressing a jury at all like he thinks he's doing.
Occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the
No, I haven't seen a judge act that way. We'll get to that later, I think.
hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself, So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question and make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mhm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mhm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
It was more than 300. It was 325 plus 44,519, something like that.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that most out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case by case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now.
That's something I never do is switch topics. I don't think that's a good thing. I don't want the witness being comfortable with different topics and feeling like, oh, this topic should be an easy one for me. I can sort of get more comfortable. I don't want them having any idea what the next question should be about as much as I can. Do that. They may generally get a sense I'm on a topic and I won't let go of that topic, especially if they're lying about it. I'll drill down on questioning if I sense that they're lying about something. So I think that's probably the number one thing attorneys don't do is they don't know how to think on their feet enough to go down the rabbit hole of the lies, to follow the lie. Because most of them have a script, just like Alessi's going through a script here. So he's tied to the script. If you're tied to the script, you're always thinking, well, okay, I'm half listening to this answer, but I'm also thinking about my next question. I'm ready to look down at that. And you don't have that eyeball to eyeball contact, looking at the witness and giving any kind of intimidating stare down at the witness. So anyway, and then I think you just got to have more yes no type questions. You got to know what and have a good idea what the answer is going to be. And so something that's really fertile ground that you can build some good points with the jury is like how much money this guy's making. And think about it. Jurors there, they're taxpayers, they're helping foot this bill, this almost $400,000 that the Commonwealth recklessly spent on this kind of testimony.
Is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, Paul?
Yes.
And
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you?
Well, this issue about declaring someone hostile, that's if they're your own witness on direct. Automatically on cross-examination, anybody from the opposing witness list that you're going to question, they're automatically considered hostile. So that's just like something you ask the court if your own witness is being non-cooperative, non-responsive, and you want to ask more leading questions. It's sort of like leeway from the judge to treat them like they're a actual cross-exam witness instead of a direct exam witness.
You know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2020.
Okay, Jessica, you're saying this guy, you're 32 and this guy comes across as smug to you. So that's interesting. Different generations think of credibility differently. So that's good. You have the same impressions as it looks like most of the other chat tonight.
24, is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days, okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would,
engineering company. We bill for our time.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you
Yeah, right.
are a senior vice president of Aperture, are you not?
You be working 8 months on a case and not know if they paid the bill, and you're the main lead expert for the Commonwealth?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on the
So he's flown out there on Sunday, and today is what, Wednesday, and he doesn't know if they've paid a dime? Yeah, right.
case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024.
Yeah, Leslie said the date wrong, or the year wrong.
So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill.
I just don't think it's as a good of a way to make the witness. You don't want the witness feeling comfortable. So telling them when you're moving on to something else, you want to get through this quick. I just don't like making. I think it's a good idea for attorneys to make people comfortable, especially when they're against your case. And this is the last witness they got. This is the last attempt they're making to try to show that Karen Reed is responsible, because they haven't done it with any single witness to date.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it.
His body language is like, I'm not going to give you anything. I don't even care if it's about billables. No matter what, I'm just going to resist you every step of the way. So he thinks he's like looking good in front of jury, but he doesn't. He's coming across really, really obstinate and really like unlikable. And here's Alessi just trying to, it's like pulling teeth, trying to get him to talk about what they got paid. And he's just not credible. So if he's not credible on something like the billing and how much obscene amounts of money they've gotten out of the Commonwealth, then how can you trust them on anything else?
Correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
Yeah, but you bought it in Texas, probably had to pay a couple $1,000s to have it transported out there, because those emission control things are different than what they would have in Massachusetts. And I don't think you could even sell that car in California with non-compliant emissions. So there you have it. You'd have to ship it out of state again. So
Okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
it's-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the
I believe that's correct. Like you're not sure. Of course you're sure. He's trying to make it look like this is not a big deal. The money, he's not there for the money.
Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on
Oh, so there he is trying to come across like, oh yeah, I'm not an attorney. I don't know about all these details. I'm not in it for the money. That's up to the lawyers and the accounting folks that work for the business.
top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
See, he's even telling that's the second time you asked me. So the guy's coming across like a wise guy, and it's like pulling teeth, but he's making the points that he needs to, and the jury is just not going to like a guy like this.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question
him.
is, you've been on the case, you
Look at that snotty, disrespectful tone.
The second time you asked me, no, I'm not aware of anything we've been paid.
So he's smarting back off to Leslie. No, the second time, and he's acting like, Leslie, you're stupid. I'm the smart one in the room here.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct?
I think Alessi got it wrong about the 6 months because it's 8 months, but just look at his body language does not come across well at all.
About how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months,
Oh yeah, I mean it's a mental strain just trying to deal with a guy like this who just won't just give a simple answer.
of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you on it?
Yes.
May I put you on it?
Yes.
Thank you. Sir, may I ask you-
Yeah, could you direct me so we're not wasting time?
Well, if you're, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
There you go.
I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh.
All
Or
right,
would you like me to start with
So-
refresh?
go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for
Hey, we can be angry about the way this guy's treating the case and his ridiculous testimony, but I want to keep the chat clean, so don't be calling him names and no swearing. So
my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve.
he's trying to pull Alessi into his mud pit, and Alessi's just spinning his wheels trying to avoid getting into this guy's mud pit.
that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right.
So I think that's something that they're trying to do, is just claim stupidity on the numbers, and he's the one that's even signed the contract. He's a senior executive, he's a principal and a vice president for the business, and he's the main expert directing everybody else and what they're supposed to be doing, and he doesn't know anything about whether they've got paid or not. Come on.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that?
Okay, first of all, it's been reported, I know other channels said he made 270 million. That is not the case. It's a different company. So that's not true. Nani's Treasure House. Maybe it was for a few million or something like that. There's no way in the hundreds of millions. So it's another company with a similar name.
Statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now,
Oh,
switching topics.
Okay.
Your direct conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement?
okay, so he's saying dog in the hunt, right? He's already talked about the earlier dog in the fight is what Alessi says, but now Alessi's saying dog in the hunt. So
Statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now,
I mean, why would you correct Alessi? You just say, yeah, in the fight. He's like taking pride, anything he can do to try to make Alessi look belittled.
switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on
Yeah.
one second. Dr. Welcher, I'd ask that you not do.
Not look
any
at,
of
okay,
that.
I was going to try and answer his question. My apologies. I will.
Yeah, he's doing all this messing around on his laptop. Very strange. What expert brings a laptop up there with him and a notebook on top of it, a 3-ring binder?
Shut it down.
Thank you.
You're welcome.
If I may, Your Honor, please
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank you, Your
please.
There you go, judge calling the sidebar. She says she's going to cut back on him, but thankfully, Brendan's not doing a lot of objecting here. Let's jump ahead.
I need you over there. So,
Your Honor, yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me
I guess maybe the judge did something good that time and had the sidebar to say, hey, we got to police this guy up from constantly looking at his laptop.
a question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
I wish Alessi had been more specific about what things he made changes on, because there was different discussions with the attorneys and the judge about things he had to keep out, references and whatnot. So it's sort of a broad question, and Alessi should have gotten more specific, because they do this goat rodeo thing here. It takes a while.
So that's addition I made was taken out. It wasn't in my
Yes,
direct
sir.
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen.
Madison Erickson, what can an attorney do when a witness is obviously lying, but you can't necessarily prove it? Well, you may not prove it in terms of what they actually admit and what you can get them to concede on, but demeanor and likability they're both very huge things that the juries look at, and based on that, the testimony could be flawless. It could come across as like having a perfect, smooth answer for everything, but that in and of itself, the jury may not like the person, their arrogance, the way they talk down to the lawyer. So any number of those reasons, if they're not likable, they could even be telling the truth, and it may not matter. So there's a lot of other things you could do as an attorney. The example I give is like with Charlie Edelson when he did his 8-hour direct examination on his murder case there in Tallahassee, Florida, almost 2 years ago. And he was so it was so rehearsed. It was so terrible. But a lot of people, wow, he really handled it well. He came across so smooth and everything. But no, he came across like a total manufactured liar, and he was just making this ridiculous story of how he was extorted and blackmailed, and it was just utterly laughable. So it's not always that you have to have like a Matlock or Perry Mason or some kind of cross-exam where the witness actually implodes and it concedes all your points. So most of the time it's not going to be that way. So I think this guy, unless he's spinning his wheels with this guy, but overall, this guy's coming across as unlikable. So in the end, you got to score it for Alessi so far.
When did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now,
See, I wouldn't want to have this come out. The judge is telling you to remove stuff, because then it sounds like he's just making changes that, other people tell him to make. So what substantive changes have you made after talking to Brennan? That's the main thing you should be asking.
version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut.
No, attorneys don't switch up during the cross or at direct, even unless the attorney got sick or something, had to leave. But no, I've never seen that happen. Judges wouldn't allow that in America.
The chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed
So it starts 22nd. He made his last change May 13th. That's significant.
your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your,
13th.
pardon me?
Oh, no, oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then
This is the kind of stuff, clear it up, Alessi, and just not let this guy start going off on all this minutia.
when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what.
Well, I think they need to go into the issue I brought up this last night and also again tonight about him being excluded and having some bogus, inadmissible type things in this slide presentation he had that were inadmissible in another court in Massachusetts just in 2022 because he's using things like cadavers and crash test dummies, which, according to his own write-up he did in 1994, I believe it was. Those kind of things aren't reliable for accident reconstructions that people like him do the work on. So anyway,
what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
I changed one slide. There was 130 slides originally or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change?
I mean, instead of talking these changes, get to what change you're talking about. It has to do with the date variance, the time variance, I mean.
Significant.
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way.
Yeah, don't let him weasel out with this kind of explanation. As attorney, you should get into the heart of the matter, which is you changed the time variance. And that's a critical issue on this case.
It was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that
All right, your question here, thrombosis. The finally I read about this guy before switching to his testimony. Yeah, that was filed in a different case, but it was in Massachusetts in 2022. And you're saying if it's different, how has the judge not seen that? Well, because maybe she has seen it and just didn't want to follow it. I don't know. I can't explain it. I don't know why the defense hasn't brought that up to exclude this guy from making the causation between the car and the bodily injury for John O'Keefe.
I gave the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Mm-hmm.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that, so
trying to
just
be helpful.
Close your
He's again looking at the computer. I've never seen this before. I've heard other attorneys commenting today. I've never seen any witness, including experts, sitting there scrolling through their laptop computer while they're on the witness stand, especially in a murder case. Come on.
Yeah,
computer
let me
and-
close it. Sorry. I was trying to answer his question.
He's trying to answer a question, yet he, as Sharon points out, he's not answered a simple yes or no as of yet.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat. Thank you.
Thank you, Your Honor.
Why is it even up there?
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecutor.
I don't think that he's trying to be irritating. I think this is the way he just comes across. He testifies a lot. And this is the way I think he gets a kick out of it. He thinks it's a game, just to never answer yes or no to any question. Just constantly put spin on and deflection on anything that's thrown his way from the opposing counsel.
That you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending?
Yeah, I think Alessi gets a lot of forgiveness and grace from the jury because he's likable. He's not a slickster, and he has that kind of conviction in his voice and his mannerisms. He's just a believable, likable attorney, which a lot of attorneys don't have that. And so I would say that he is winning, even though many of you think he's not scoring a lot of points with the jury. From my experience, my jury experience, I'm confident that this guy is just not likable, and because he's not likable, the jury will not take much stock into what he's saying and all the technical stuff.
To submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
Meetings and discussions. Burgess made it sound like they really didn't do much discussions and collaboration.
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an
I guess Alessi's moved away from the mic because we're not hearing him very good.
amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
Always saying you're welcome. I mean, that's just really bizarre. I've never seen a witness do that.
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess? Again, Dr. Welcher.
Great. Love to do the rest.
Okay, we can jump ahead to 303 or 301.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened.
He's trying to sound relatable here to the jury, but he's just rambling, and they just want to get through this witness, and this kind of belaboring rambling is just not going to be well tolerated by a jury.
It up, and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about.
Yeah, Leslie's got to be a little bit more pointed on his questions here. Willow's Angels, you've always found Karen Reed to be not guilty, and how obvious it should be to anyone with common sense. Having said that, does Welcher's testimony throw doubt on her innocence? No, I don't think so at all. And we're still not done a cross-examination. I don't think the guy's credible at all. I think he's coming up with such whacked out theories, and it's just like a fifth grader is trying to come up with these kind of stories of how John O'Keefe would have been struck by Karen's car. It's really laughable. So I can't believe this guy is embarrassing himself that way. And by the way, save your money. Just help Karen Reed's defense. But
What's the goal? I mean, there's been
you don't
scheduling.
need it, but thanks.
When am I going to come? Things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Can't even hardly hear Alessi.
Going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location.
Yeah, so lawyer on call, Leslie should have called him out more on the changes. AJ would have driven him. So we didn't really get any great points out of that on what things he was changing.
Location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Are you not?
asking a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data
Mhm.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream.
Occurred
Well, I don't want to get that.
with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is
He's just being evasive here. It's a simple question Brennan's asking.
with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So,
Yes, that's a yes. Go back, listen to this.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So
Clearly, even assuming all this weasel answers, like the totality of all the information or evidence, yeah, if the totality is what you have known at the time, if certain data points are wrong, then the outcome is wrong too of when the text stream event happened. That's a simple question.
again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
But it doesn't tell you the time of the day, though. That's what I think the difference is. I don't think that the text stream data tells you actually the time, the exact time of the day that's happening. It shows you how long it happens for, but doesn't tell you the time. It's not like a clock.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the tech stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way.
But you still have to understand when that happened, and you have to, if you don't understand when it happened, then you could completely be off on your conclusions about when a vehicle striking a pedestrian happened.
Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the tech stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Oh, so
Again, you need to take the totality of the data. So that is one
Totality.
element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of tech stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the tech stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me,
What
Your-
slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 tech stream events that
Actually,
are,
can you zoom in on the key cycle?
oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So if we can go back so we can see the 4 tech stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 tech stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 tech stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that,
Are you saying there's no basis for the question? All right, I'm going to allow the question and I'll hear it.
you are aware
Hank doesn't want it coming out that the Commonwealth has been flip-flopping on their story here.
that the Commonwealth has maintained up until your engagement in September of 2024 that all tech stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Alessi.
He hasn't had
Sir,
foundation
as
for
part
anything
of
else
your,
he's testified to, and now he needs to have a foundation for asking him stuff on cross. What happened to the wide latitude the judge promised the defense on cross for this guy?
work, in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, that base, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of
correct?
course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
Yeah, I think Hank objected here. So let me jump ahead. I like the tone of Alessi's being more aggressive, taking control. I think he realizes he needs to be more pointed with his questions. Goes all the way to 326. There's a judge
May I,
in her
Yes.
chair.
Thank you.
Not happy with the defense cross-examination taking this long.
Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Ronnie. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Alessi, court reporter coming.
Thank you. I will.
Thank you.
I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure. do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that.
Okay, understood, Your Honor.
Of course he does.
Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
What the heck?
Ask for an instruction.
Do-
That shows that the state doesn't have accurate data, and they're trying to constantly align the data based on what other new information they got, and that is definitely exculpatory type information that the jury needs to know about, and this is what the defense is trying to bring out. So this is another violation here of the constitutional rights for Karen Reed's defense if this doesn't come in.
I'm not giving the instruction now.
Dr. Welcher,
Unbelievable.
in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about that.
Yeah. Getting too close to the truth here. Got to shut it down there, Alessi. You can't be pointing out the fact that Commonwealth can't get their story straight. They should be able to change it and act like they've had consistency ever since this event on July 29th of 2022. So now we have another wasted sidebar for about 8 minutes. Think of all the time this is wasting. There we go.
Excuse me. Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes,
And you go on to add on page 9, my biomechanical engineering analysis is determining
I got rid of that troll. If you're going to try to blow up the channel, I'll as soon as I see it, thanks for telling me.
the effects
After.
of physical forces on the human anatomy. Did I read that correct?
you did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So
You know, he could bring up the fact that you're not even allowed in the Massachusetts courts to testify on a civil case. In fact, you've been banned from testifying in a civil case, rejected from your attempts to testify as an expert in a civil case just in 2022. Anyway, I just am surprised it wasn't brought up at any point today. I would have thought they would have brought that up in the beginning, but maybe the judge will try to keep some of that out, just like she did for that Hyde witness for the Commonwealth.
you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get.
I've never seen that, Mr. Monk's understudy, for the witness to control off a laptop like that.
Newton's second law
Okay.
is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission. So
Sorry.
if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
Very long question. And he says we're not talking about that. Couldn't quite hear. He's talking about Newton's law, first law. So
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's
Uh-oh.
second law is generally just a mathematical calculation, correct?
Yes.
So
No,
what I'd
no.
like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches at that fall, Mr.
yeah, test dummy. See, this should not be allowed, him doing that test dummy stunt.
O'Keefe's head would have accelerated with 450.
I don't know why the defense didn't object to it. They've seen this report since January, and they knew he's going to testify off this 140 slide page report. And yet, I don't know why they didn't do motions to keep this out.
58 G's of force.
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you use the acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you
I don't agree with Andrea. Mr. Monk's understudy who said he is doing a good job as an expert witness because his job is to obfuscate. And he's doing quite well. No, I don't think he's doing good at all because he's not credible or likable.
You estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone.
Okay, as I understand, just talk about these key cycles. So key cycle is turning ignition switch or pushing it. I guess in the Alexa it'd be a push button. Most Alexas now don't have keys that you stick in like the old-fashioned way and turn the key that way. It's just like push button. But anyway, for the key cycle to take effect, starting or turning it off, then the whole period of time it's on, it's telling it, I guess it will show how long the car was running, but it's not so concerned with what time of day it was running. And so if you backtrack the key cycle when the vehicle was brought to the Sally Port there at Canton Police Department, if you backtrack the number of key cycles from when we know the vehicle was in use, it's like the key cycles that are making a big deal about this 1162, it was already in the possession of the state police at that time. So that's what I'm understanding this whole thing is about. But if I'm wrong on that, can somebody clarify that for me? But That's what I'm gathering from all this. So I think it's sort of like in the weeds on a lot of this stuff, that the way the questioning's coming out from both sides. But I think that's what the latest that I understand it to mean.
In an average force of 634 pounds.
No,
I'm sorry.
1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all
For
right.
an impact, it does.
Now let's go to the.
That doesn't make any sense. Acceleration, no, the impact, what it lands on, obviously, if it's a soft object, that's going to have different effects on the body if there's a strike. But anyway, this guy is so evasive. He's sort of like mocking, in a way, he's mocking Alessi here. So this is not coming across good to the jury.
Study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you.
Well, he needs to try to make more precise questions to try to get him not to elaborate. But this guy, I don't think there's really anything he can do other than if you ask him something for yes or no, he's going to say, well, I can't answer that. And the judge is not going to force him to do that. So I think Alessi's doing the best he can at this time for what his style is.
It's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the. That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document being referred
Do
to?
you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in
Yes, he did. And he should not be allowed to get percentages like that.
impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
Yeah, right.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old. Therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Hey, that's about a source.
No, I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mm-hmm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature.
So-
I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I mean, how many people get hit head first or head only in a vehicle strike if they're a pedestrian? I mean, this is like common sense and he won't even admit it.
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
The
you.
general concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart
Yeah.
comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay,
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury or
No, she's the worst imaginable.
associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You're welcome again.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you
That
recall
whole-
that?
Correct. It's actually,
That whole fin thing is so ridiculous to say that he got a laceration because the spoiler on the back of the window there. There's nothing physics about that or scientific about it. So, in any event, I think it's after midnight here, Central Time, United States. So I'm going to go ahead and we got a couple hours left of this. There's a lot of breaks in between, but I'm going to go ahead and end it for tonight, and I'll be back tomorrow. They're having just a half day tomorrow because one of the female jurors has an appointment to go to. I guess some kind of medical appointment. So I can cover this again tomorrow night, and we'll cover we'll cover all the rest of his cross-examination at that time. So thanks for your support of Justice for Karen Reed, and hope to see you back tomorrow night. Take care. Have a good one.